been accepted. And then we don't go back on every single proposal to explain why or why not they have not been accepted in the budget review by the minister. A couple of years ago, because we were getting quite a few comments to say, but we keep putting forward proposals to Treasury, but we never get any feedback on why they aren't included in the budget review. So a few years ago, we did have a meeting where we tried to go through all of these issues to say, these are the proposals that we've had. This is why we didn't. There have been calls to say, can we do that again? And I think that's a reasonable request. So we can look at doing that. There are a lot of them and we can go through them. We do try and consider all of them, but I think there is a concern that, especially from some taxpayers, they put a lot of effort into putting these proposals forward and they don't know if we've even looked at them. Whereas if we have something to discuss, they will know that we've looked at them, we've considered them, but haven't been accepted. Those are the two ones on the side. There's just a couple of points more about the timing that I'd like to raise. So there were concerns that it takes too long between the budget, which announces all the tax proposals for the year from the minister in February, and the time that the draft legislation is part comment. And in previous years, we've had a lot to do. There is a lot to do to get those bills together, sometimes in excess of 100 pages of legislation. So it does take time to put together. But I have been saying to the team, we are going to see if we can try and shorten that process to give more time for the public, but also for the committee to then consider. So we will go away and see what we can potentially do on that front. On the HSC process, there was also a comment there about, there isn't much time after we tabled the bills, which we've just done at MTBPS. Then we put out a letter and an HSC letter to say, if there are technical amendments, can you please put forward technical amendments? And then we will discuss, have a workshop, and those can potentially go through into the next budget 2026. Now, timing again is quite short. But the reason we've always done this is because we didn't ask for technical corrections, legislation that hasn't been finalized yet. So if you did it earlier, you might get a tabled bill later, which has a change. Now they want further technical corrections on that. So we would always do it at one point and say, okay, after the bills have been tabled, then we will do a letter. But commentators are saying they also don't have enough time. Also put a lot of pressure on us, on Treasury and SARS, but if this time is quite late, because suddenly a lot of these technical corrections, Ember December, need to potentially be included in February. So it is difficult on both of us, and we're going to also weigh and think about what we do to fix that. I think our previous concern is that if we open this up earlier, then A, they won't see the final bills, but B, it's just enough for them to try and change the current legislative cycle and the current taxation law amendment bill or TAB. So as you would have seen with the hearings, we don't normally do hearings on the table bills after the requests are the same. It affects taxpayer or others getting another bite of the apple to say, well, I still don't agree with what you've said, so I'm still going to do another submission. And you've seen a lot of these submissions are very similar, or some of them are exactly the same as to what we had previously. We're commenting on this thing, which is why we haven't done it before. But some additional ones here. If we change the Annexure C process that it could potentially be earlier, we do need to just be wary that those suggestions and proposals that we had and have workshops on, they should be included in this round. We can't iterate forever on these bills. We need to come to a finality, and we will start again next year. And those are a couple of concerns we have. But I think we've taken the point, and it's all input on the process. We're going to go away, sit and think about it and see what we can do to try and make it easier for taxpayers, provide more feedback on the comments, as well as making it easier on ourselves, National Treasury, in terms of not having such tight timelines for some of these issues. Thanks, Honourable Member. I think we'll move now. I'll hand it to Zalile on some of the personal income tax aspects.
Thank you, Honourable Chair. Thank you, Honourable Members. Thank you, Chris. Good morning. Chair, we did receive comments with regard to the reduction of the threshold for repurchasing of assessed losses. We will be reducing the marginal rate from 45% to 39%. And the special comment that received was with regards to the buy to rent in the property market. And there was a question we should apply carve-out on this type of trade. Also, we received another comment saying that the existing safeguards are not adequate for the fixed property industry, particularly when one has finance finance costs for the mortgage fund. Next slide, Mbo. Thank you. Chair, response on this one is that the buy-to-rent areas, we have the view they are not classified as a suspect trade under 20 Cap A subsection 2, which actually says that in terms of A, is that if you have actually during the five period, you have incurred assessed losses at least 3 years in the 5 years, then would be fencing that applies. Or in terms of section 3, in terms of Cap A, which says that then which actually lists the suspect trades themselves and the buy to rent arrangements, we do not think that they are classified under subsection 3 as a suspect trade. Thank you. Next slide. Chair, honorable members, the amendment to definition of remuneration proxy, we receive a comment there, which that we should be withdrawing this proposed amendment. Chair, this one is not accepted because of considerations of treating all taxpayers consistently, within that foreign employment income that was previously exempt in terms of section 1 or it should be actually be part of the termination of remuneration proxy. So we withdrawing this proposal actually not to assist us in terms of moving in ensuring that all remuneration, whether domestic or foreign, should form part of the remuneration proxy when it is required for us to determine the amount of remuneration. But we still maintain that employers can apply a gross-up mechanism to mitigate any impacts on affected employees. Thank you, Paul. Chair, was another amendment which actually was saying that should be excluding ship members and officers who receive foreign employment income or foreign remuneration in terms of section 101. Chair, it is not the objective or intent of government to exclude ship crew members and officers who receive form of remuneration. So they are part of this proposal. So it is the objective of government to that. Thank you, Chair. Thank you, honorable members. I'll give over to Chair or to Mr. Khatebe to continue. Thank you.
Thanks, I can go. Thanks.
Okay, thank you. Good morning to everyone, Chair and honorable members. I'm just going to take you to the next slide more. Okay, the key issue here was what we have seen was that the current tax rules for the collective investment scheme have intentionally enabled tax avoidance, particularly when investors transfer appreciated shares to CIS without triggering the CGT. So in effect, that's what we're trying to do. Now, the other thing, well, that you just want to draw to attention to Chair and honorable members is that these avoidance transactions resulted in SARS releasing a press statement, back in September of 2016, warning against this abuse. Now, the comment now that we're seeing that seeks to suggest that the inclusion of these provisions are flawed, we actually not agree with it. If we go to the next item, Paul, a response. We just want to mention that this proposal on the table bill actually care for the prevention of the issues and also catering for the fair consulting, as we actually received that from the commenters. And I think one of the submissions that was made to SCOF by PKF it was welcoming the end result of the proposal. So and the only issue that we then need to discuss next year, it's in relation to what is to make it different between a closed held and widely held. Now, the part that needs us to engage FSCA to define a definition there. Thank you, Paul. Slide. Okay, Arno.
Good morning, Chair, members, and stakeholders. Next issue relates to the proposed amendment that we made this year in Section 42. Essentially, Section 42 is a rollover provision together with various avoidance creation measures entails that the acquiring company install shares both in the same tax character, i.e. as capital or as stock, and at the same applicable tax cost as the company shareholder immediately before the transaction. So more specifically, our 2025 clarification, the spill rollover relief, into what is known as the tracing rule, we clarified the legislation that for the tracing rule, it applies to those shareholders that hold less than 20% of a listed company. The theory behind it is it's impossible for the purchaser to chase, as an example, 150, 200 shareholders to find out exactly at what they hold that stock and at what price. So we clarified that 20%, and it was generally welcome. So the comment that we received here was that a 20% rule might be problematic for instances where you've got shareholders that have more than 20%, and the purchaser is unable to identify the base cost of that shareholding. So to the next, this is just accepted with the 3025 rule that we have as an anti-abuse measure to ensure that these all-over rules that have a sizable transactions, together with 20% rule, legislated quantitative tests to determine whether relief applies and how it should apply. If we allow for the 20% rule to be ignored, essentially it would mean that the shareholders, the company, and more than percent would step up in the base cost, which is not the idea. The whole idea behind the rollover relief is to get the same use as the person that you bought it from. If, for example, they bought share in 2013, you get that share at the same value as they purchased in 2013. It's a rollover relief until such time that you sell it. Right? If the score at the 20% rule, unfortunately, it does put us in the position where this structure can then be utilized to get these undue benefits, which merely supposed to be administrative from our side and to help these companies not to have to chase up a certain shareholder that owns 20 shares. So when you get to a level of you owning 20% of as the company, it's unfortunately outside of prerogative and our policy intent. Thank you.
Okay. Then, honorable members, I'm back again on the next item, Paul. Okay, now this one relates to the issue that is actually the current law lacks clear guidance on how to treat capital distribution from a fund that is operating. So that was the main issue. Since there is no specific rule for capital payment to funds ongoing operations, we then came with this proposal. Now, at first, to us this gap, we stated it in the discount document. It was released in December 2024. That we seek to make amendment, but also proposing to adjust base cost of the participatory interest CIS when the capital distribution occurs. Now, however, the feedback that we received down on the next slide. However, the feedback that we received, just like one of these ones, this one is from Old Mutual, because this is now been read by Old Mutual. They stated, look, there is an issue because they cannot access the data. They can't access the invest data, making this proposal impractical. Now, we then went ahead because of suggestion that came to say maybe it's actually best that you propose make all capital distribution to be regarded as capital gains. And hence, we made that amendment. But I think the key point that we have to allude to this response is that we all received the same submission from Oshal, highlighting the fact there is some complexity with our rules we suggest in 2024 of reducing base cost. And then next, Paul. And hence, some of the suggested proposals as well, where we deemed all capital distributions to be capital gains in order to avoid the complexity involved. Thank you. Next item, Paul. Okay, now on this one, certain issues that were not in the text. One of the issues that was raised was in relation to the taxation of unlisted properties. Now, we had stated in the 24 response document that we will, National is going to release regulation in this regard. So, 30. So, if we just wanted to, we noted, and the first that notices are under condition by SCOF, and there isn't any amendment. However, we are currently processing an internal memo requesting publication of this regulation public. Next slide. There is one with respect to an extension of Section 9. Now, this anti-avoid rules. Now, the key here is in much as the data state that the related National Treasury number of 2024 that we needed to make an amendment to cater for the CI and hedge fund. Now, the issue then was that at that moment in time, there was a discussion paper that seek to exclude hedge fund from the CS regime. Now, that discussion is still under consideration. However, we do notice a proposal from the commentator that says, to the extent that we make an amendment, the amendment should be retrospective to date back 2024. So I think that's the only that we can say there. Thank you so much. Thank you, Mr. Or you
I
can
think
go
we
to
can
next.
Good morning. Thank you. Good morning, Chair, good morning, members. Only comment received this round to do with the size of additional services. And the comment was deferral of the main part to 2027 outcome. However, what was raised is that there may be some practical considerations and challenges that require further consideration. For example, the mechanism to removal from the VAT system may invariably mean that they stay on that system until the end of 2027, and that still continue to render the proposal be withdrawn for the engagement with the issue as to the practical implementation of the proposal to ensure the transition out of the VAT system. Next. The reason why accepting this proposal, following parliamentary we had on the 4th of November, where Treasury funded to the ministry supplements by taxes, National Treasury and SARS with ISA call is a main representing the private schools in the country. We met as a representatives, so they were apart from the bodies representative, they were also representatives from the member schools, and they also had a legal representative from Weber. So the concern that they raised was that some privately funded schools operate on not-for-profit basis. So they set up the school in a way, for example, Partner of Basic Education has been unable to set up. It's not specifically one of those exclusive schools. No, it would be like a public school in that year. And so it's not profit, they don't see much funding, so no funding at all. And try to raise it through schools and other stuff. The is passed. They did receive legal advice, not from home and isn't really matter. The rest was kept. And the advice, what they based their VAT on and claimed input tax credits in areas where the VAT Act not an input tax credit. So now the problem is they have to register and they have to now pay back VAT that was previously as input tax credit. Not only is the
resolving disputes when a taxpayer believes an objection is valid and the SARS believes that it is not. We simply don't have that kind of legislation in Section 11.4 on its current form or its proposed form. The High Court rules don't go in this direction, and probably most critically, moving on to the next slide, if there is a dispute about this, because there is no ability for SARS to reject the notice that has been provided, the best that SARS can do is go to court and say, we disagree, we don't think we were given proper notice, and it is for the court to decide whether or not that is in fact correct. And that is all predicated upon the fact that this provision starts with, unless the court otherwise directs, a notice must be given. So the discretion is always with the court as to whether to allow a litigant in the door, notwithstanding they're giving us no notice whatsoever or giving us defective notice, if it is in the interests of justice to do so. Now, the point has been made that 10 days is more than enough. We'd just like to draw the committee's attention to the fact that that 10 business day notice period is rather short when you compare it to some other acts. So in the Customs and Excise Act, it's a full month. In the Road Accident Fund Act, it's in fact 4 months, essentially. Moving over to the next slide. And with respect to the legal proceedings against certain organs of state act, that is even more restrictive. So it's not surprising that it deals with restriction of access to court, because that gives you 6 months to come forward. If you come later than 6 months, you have a much higher hurdle to climb. So there's no equivalent in Section 11.4. You can a year later come to SARS and say there's something I'm dissatisfied with and I intend to take you to court. That would not be the case in this other piece of legislation. And then just to make the further point, that piece of legislation allows 30 days from the date of notice to when proceedings may commence. So the analogy we would respectfully suggest is flawed. I would just make one further point. I referenced the Customs and Excise Act on the previous slide. Now, that act has had a form and manner requirement for many years. And it's the same litigation team at SARS that deals with both tax and customs. They all fall under our chief litigation officer. So it seems a little odd that a form and manner requirement in the Customs and Excise Act has not given rise to any of the difficulties the commentator foresees, but similar requirement in the Tax Administration Act would. So moving on. We come to the clarifying of the bona fide inadvertent error. The commentator here suggests that we're seeking to circumvent fault. Monetary thresholds are not an appropriate basis for imposing a penalty, and you may be deemed culpable and then have to prove yourself innocent. So moving on to the next slide. So we would suggest that this comment is misplaced. So first up, we'd make the point that the comparison with criminal law through terminology like guilty is just not appropriate. Criminal sanctions are dealt with separately in the Tax Administration Act. We are firmly in the realm of administrative penalties here. Next slide, please. And we have case law that administrative penalties and criminal proceedings have completely different purposes. They're set out in the slide there. But perhaps a key point to make here is it's well accepted that an administrative penalty is something that can be imposed first and then mitigation can be applied. That is the case in South Africa across a number of various pieces of legislation. In the tax world, the one you may be familiar with is, of course, the penalty for late submission of a return, which can be remitted under certain circumstances. But if you are late, you have done something wrong, and therefore, maybe that wrongfulness is excusable, but we start from the proposition that it is late. Similarly, in the environmental space, there are administrative penalties. And then perhaps the one most people are familiar with is in the traffic offence space, where a fine may be imposed and then the opportunity to make representations as to why that fine should not have been imposed are available. And there are international examples of where this occurs as well. So moving on to the next slide. So the first point we'd make is in response to, in fact, another commentator's suggestion, we have proposed an amendment to section 221.222 subsection 1, which makes it clear that the behavior has to fall in those categories in order for a penalty to apply. So there are degrees of culpability that are set here, and it is only the lowest one that is essentially imposed first, and then a remittance is possible. So that's an important point to make. It's not that it's imposed and no remittance is possible. Remittance is definitely possible in the case that you can demonstrate that there is a basis for remittance. And SARS must demonstrate that you did in fact fall under one of those categories. So the facts are there to justify it. Moving on. So where does this substantial understatement penalty come from? So we go back to the parliamentary hearings on the Tax Administration Bill in 2011. And here's the point. It's there to act as a disincentive to taxpayers taking aggressive positions where large amounts are at stake. And the large amounts is a key point here, because ultimately, it's quite possible for someone to take a position for a large amount. And then if they lose, well, the worst that happens is they pay the tax and the interest. So there's in fact no disincentive to taking these positions. So hence we have a substantial understatement penalty. And how substantial is, we'll get to in a moment. Moving on. I think this is a duplication again. Moving on. So during the course of those public hearings, the point was made that it was rather unfair that large taxpayers would be faced with a penalty that could not be remitted. And so it was recommended in the course of the hearings that, in fact, this power to remit be provided subject to a diligent approach to tax compliance. Moving on to the next slide. So this proposed amendment is a continuation of that line of thinking. So if you have a substantial understatement and there's been a diligent approach, then the penalty should be remitted. If there was not such a diligent approach, then it should not be. So let's have a look at how big an understatement we're talking about here. Next slide, please. So this is a company. We've got 3 companies, and really the most important part here are the last 2 lines, but in summary, we have companies with a 10 million rand taxable income and 2 with 100 million rand taxable income. They have tax on it, and I noticed some zeros have disappeared in the course of this being transferred onto the slide deck. We have a situation where, in fact, all 3 of these companies have understated their taxable income and therefore their tax. And you'll see that the first company understated it by 405,000 rand, the second one by just over 1 million, and the third one by just over 2 million. But because the test is that the understatement must be greater than 5% of the amount properly chargeable and 1 million rand, the first company does not get a penalty, even though as a percentage it's 13%, because it's under the 1 million rand. The second company is over the 1 million rand, but it's only 3.8%, so it's fine as well. No substantial understatement penalty. Third company, on the other hand, has an understatement of 2 million rand and over 5%. So it is the company that will now have to justify as to how it got to be in this position. Moving on. So how does the company do this? Well, the proposal is that it be permitted to escape a penalty if there was a bona fide inadvertent error, or, and this is existing law, the second part, it got an opinion in support of the position from a registered tax practitioner that indicated that its position was more likely than not to succeed. Now, there's only one person when SARS and the taxpayer are in the room who knows whether it was really a bona fide inadvertent error and can provide the evidence for that, or knows whether they got the relevant tax opinion, and that's the taxpayer. Moving on. So just as a counterpoint, we have another commentator who has looked at the changes that have been proposed as a result of the first round of public comment, and is in fact of the view that we have made things much clearer and that it assists significantly in addressing their concerns, and we would suggest that this comment should be noted. I think that is it from my side. Thank you.
Thank you, Chair. I think that finishes from us. Happy to take questions.
Chris, are you done?
Yes, thanks, Chair. We finished.
Okay, thanks very much. National Treasury and SARS. Let's move to the comments by stakeholders. 3 minutes each. PKF, are you there?
Yes, we are, Chair. Good morning, all. This is Prabashini Mudli from PKF. Firstly, thank you, National Treasury and SARS, for those detailed responses. With regards to the new process, I think we mainly focused on the timing. And so we are thankful to National Treasury for agreeing to actually relook at that and strike some sort of a balance as opposed to where we are now. With regards to the impact of these workshops, I think although it was stated that by Mr. Axelson that, you know, a lot of this is a repetition of the previous workshop, I agree and disagree on the basis that it has been quite impactful in terms of some of the submissions that have been made. There has been some changes that have been noted here. And also, it's not just to look at only the technical detail of the revised bills. So I think we have achieved quite a lot in this extra process. And extra C recurring workshops, I think we really do welcome that. Thank you to the National Treasury team for looking at that, so that we do have proper engagement on recurring proposals that are not addressed. With regards to the assessed loss response, I must say I accept possibly that the buy-to-rent market necessarily doesn't just fall within the parameters of a suspect trade. However, the 3 to 5 year rule, in our view, still applies. And so what we're really trying to say is, can you not rather consider this industry similar to what you've done for the farming industry, where it does take a longer time to turn a profit? And I think that's really the point. So whilst we might not have specifically said that in our submission, maybe that is something that Treasury can just relook at. With regards to the VAT, there was only one response. The issue that we raised regarding the effective date for implementation on the VAT on low value goods has been, well, it's not been addressed in this forum, and I'm not really sure why. We did make a proposal that SARS has been given adequate resources to actually prioritize this change to their system. And we proposed a 6-month to 12-month period to allow for this to occur, because we're already a year later since it was mentioned that SARS was going to look at this. And this is an immediate loss to the fiscus in not having updated a system. When we are all in agreement that the legislation should be changed, we all agree with the amendments. So I wish we can get a response for that. With regards to the understatement penalty, I just want to mention that whilst a lot of attention was being given to the criminal versus non-criminal aspect and the imposition of penalties, administrative penalties on the basis of imposition and then remission, the one thing that we really do have to take cognizance of here is the fact that the onus for the understatement penalty is very different. The onus is on SARS. And I think the issue we have as practitioners is that SARS imposes the penalty similarly as they do the other penalties for late payment and that, and then expect you to ask for remission either by arguing out of the table or arguing that it's a bona fide inadvertent error. And that term hasn't properly been distinguished. It hasn't been interpreted by the courts. So that really does give you a very difficult place to sit in. I think if SARS held and recognized and practiced the onus being on SARS to prove that you are falling into one of the behaviors in the table, this would be a very different conversation. So in that light, I think, although we did make a submission, we were the one positive submission in terms of saying we accept that it's clearer that you have to fall into those tables in order for the penalty to be imposed now. We do still think that practically this needs to be filtered down to the SARS auditors who follow the impose now and remit later principle, as with all other penalties. But this penalty specifically has to be dealt with differently because SARS has the onus, not the taxpayer. Thank you, Chair. I think that's all from me. Sorry, just one last one if I have time still. On the collective investment schemes, I just wanted to say that specific mention was that PKF was happy with the amended version. I must say that we were partially happy, not fully happy, and maybe it wasn't clear in the submission, on the basis that the section 44 removal from CISs was reintroduced, so it wasn't actually withdrawn. But in terms of section 42, I must say that we still agree with the other stakeholders that the administrators of these funds do have the ability to track the base cost of these investments, and therefore the CIS should not just be removed from both provisions. Thank you, Chair, and thank you everyone for listening. That's all for me.
Thank you, PKF. Old Muchwan.
Thank you, Chair. Good morning, everybody. I'm going to be providing the comments for Old Mutual. We just want to thank the committee for the opportunity to respond, and then we also note the National Treasury comments. With regards to the reference to Old Mutual with regards to the capital distributions of CIS, I think the quote was misplaced. our reference was actually with regards to the tax return submissions and the fact that there is no dedicated tax return for a collective investment scheme and that they don't actually fit into the CIS tax return process and the trust tax return process. We had actually supported our position hasn't changed. We had actually supported the view to adjust the base costs in our submission to the discussion paper on the taxation of collective investment schemes. So this isn't a different approach that we've taken. I just wanted to clarify that for the committee. Yeah, thank you very much for the opportunity to present.
Are you done? Well, move on.
Yes, thank you very much.
Okay, no, thanks. Web, sometimes written Web and Wenzel, but here it's written Web or Wenzel. Over to you.
Good morning, everybody. Thank you very much for the opportunity to present comments on National Treasury's responses. So I prepared a slide. I've shared the slides as well by email because I wasn't sure if people could see it. Can you see my slides? Can I just have an indication that people can see my slides?
We only see your face. We don't see
Okay.
the.
All right. Let me try and share again. Can you see the slides now? No, still no.
It's
Let me
still
try
share.
again.
Okay, there
Yes,
you
we
are.
can. Yes, we can.
Okay, thank you. So you do see the slides. So this is the Treasury response. We'll be discussing the comments on the Proviso D, Section 9D2, Proviso D. Thank you very much for the comments to say that the discussion document circulated around November. There was a paragraph 7.4, which potentially proposed to exclude CIS and H fund. I just want to draw your attention that the discussion document covers South African collective investment schemes and their taxation under Section 25 capital BA. Discussion document doesn't really apply to global unit trust global funds because 25BA doesn't apply to global funds because global funds are not South African tax residents. Also, I do want to draw your attention to a statement in paragraph 7.4, which proposes to exclude CIS and H funds entirely, South African ones, where the statement says the National Treasury and FSCA can use the regulatory framework to encourage development of the industry while ensuring stability and the protection of customers. So my concern is that what Treasury is doing now by discriminating against global CIS and H funds is not going to develop the H fund industry at all. In fact, the contrary. So my proposal is the potential exclusion of global CIS and H funds, as the comments appear to imply, is not part of the discussion document scope. It is an overreach, it is discriminatory, and it gives rise to rule of law issues. Another point I want to draw your attention to is that the discussion document was circulated for comments around 14 November 2024. The Taxation Laws Amendment Act 2024 was tabled in October 2024 with the amendment to companies to include foreign collective investment schemes in H funds. That was the amendment. Now, if it is a case that you have a discussion document which is still currently being deliberated as to how to treat collective investment schemes, South African collective investment schemes in H funds, and to potentially exclude them, why did you already have this amendment, which was tabled in October 2024? And your discussion document was only circulated 1 month later on the 14th of November 2024. So there is an internal inconsistency between the FSCA Communication 5 and the National Treasury Policy. The FSCA is very clear and recognizes that feeder funds, including global collective investment schemes in H funds and global collective investment schemes in securities, is the norm. So if it is the case that National Treasury wants to deviate from this policy, then it must clearly do so. And it must not do so in a manner which is very discriminatory and gives rise to rule of law issues. So this is the communication 5 that I mentioned. It was issued in 23rd February 2024. The same year, in November 2024, then National Treasury circulated the discussion document, and in October 2024, amended company to include global CRS and hedge funds. I think we need to go back to this communication 5 and read again. It is acknowledged that feeder funds are an industry norm internationally and should be available in the spectrum of portfolio offerings. Consequently, FSCA intending to close this gap by exempting managers of retail hedge funds from complying with the 75% exposure limit as set out in BN 52, insofar as it relates to feeder retail hedge funds. Now, by not including foreign CRS and hedge funds in proviso D, capital D, of section 9D, by not including that amendment, we are not in alignment with the FSCA Communication 5 that feeder funds are a norm. So this gives rise to a lot of uncertainty, and I want to go back a little bit on the history of the taxation of collective investment schemes. In the response document dated 11 September 2013.
Hello, Chong.
It was the current, yes.
Hello. You are aware.
If I may have 1 minute left, please. I'm almost done.
Wait. Were you aware that you have got 3 minutes?
I wasn't aware, my apologies. If I can just have 1 minute.
Okay.
Okay, the response document stated that the current tax treatment of CRS and securities will be retained and extended to regulated hedge funds. This is when the SISCA governed CRS and hedge funds around about April 2015. This is the response document to the SCOF. The EM to the draft regulations also stated the same thing. Hedge fund portfolios will be tax exempt. The same with collective investment schemes. So the way forward is that I request National Treasury and SCOF please to reconsider including the amendment of Proviso D as requested, because the discussion document deals with Section 25BA. It does not apply to any 9D attributed income. This will become unduly punitive. And is this the intention? Is this the intention to be discriminatory against global CRS and hedge funds, to go against FSCA Communication 5? And large, so then the next point is timeline, that, this is an issue which is causing great uncertainty for all collective investment schemes, not only CRS and hedge funds. Please maybe request clarity as soon as possible. And it has been stakeholder concerns. Perhaps we shall see that clarity in 2026 legislative cycle. And the comment earlier by National Treasury that amendments be made retrospective basis, potentially, that will be most welcome. But there must be a clear policy. It must apply fairly, and there must be a rule of law. There must be respect to the rule of law, and it should provide clarity in a manner which will not destroy the collective investments scheme industry as a whole. Thank you very much.
Thank you. Saika.
Thank you, Honorable Chair. Okay, can you all see me?
We can see your face.
Okay. Yes, this is a photo from SAICA. I appreciate the opportunity to present to the committee, and also appreciate the SARS, the detailed SARS and Treasury responses to various submissions we have all made. I'm just going to speak to 3 things. The first one is on the public consultation process with regards to the process from the draft tax bills to the actual bills, and we appreciate the response. I just wanted to say that what we are really, one of the things we're asking for is that the first version of the bills that's coming into this committee for deliberation, could it be the version, it shouldn't be the version that was in the draft, because currently it's a carbon copy. Treasury receives comments and then amends the draft bills, and then this is what, and then right now we're debating the amended version. So we would prefer it, and we think it's more efficient if the version that the first version that comes into the committee should already incorporate the changes that Treasury feels that they have accepted from commentators. So that's really our comment on that point. With regards to the Annexure C and the proposals that are made by commentators at the end of the year, we appreciate Treasury's responses there, and we do look forward to additional workshops where recurring items can be discussed further. And then I wanted to say one of the submissions we did make was concerning Section 7.4 of the VAT Act. That's the section that allows the Finance Minister to really amend the VAT rate, and for that changed VAT rate to only be ratified within the next 12 months by Parliament. We can see that there's been no response to that aspect of our submission. And it's very important because there was a lot of back and forth politically concerning the change in the VAT rate and certain parties taking the minister to court. But currently, as things stand, if the same thing were to happen next year, we would find ourselves in the same back and forth because there's still uncertainty on the issue. There are questions of constitutionality of the minister being able to amend the VAT rate, and that amounts to primary legislative powers, which do not reside with the executive currently. So yeah, we urge this committee to look into that and discuss it in further detail, because we haven't seen a response concerning that. And things like changing the VAT rate, businesses get ready for it and they expend a lot of money in changing their systems. And then only for the process, for the rate to not be changed and to revert to the old rate, that can be very detrimental to how business is done in the country. So we would really appreciate further engagement on that. Thank you very much.
Thank you, Saiko. Honorable members, clarity seeking questions and or comments. There we are. Do we have members who want to make comments, who want to ask questions? Okay, it seems there is clarity. Honorable Scott.
Thanks, Chair. Let me as well welcome the responses by National Treasury and greetings to everyone on the platform. Chair, just to want to comment on one or two areas, especially the one that relates to a text that relates to schools, which I think the Treasury is saying that the Treasury alone will not be able to deal with it. It needs a multi-faceted approach, particularly in terms of role players or stakeholders, including the Department of Education, to deal with the issue of the text that relates to the schools, particularly the private schools, which I think is going to be important because it would have an impact, as already shown, that it is necessary to really look at a solution that would be able to assist in that regard, because whether it's private education or public education, it still has impact in terms of the development of the country. So I was saying perhaps we really need to make sure that the Treasury helps in that regard to take the lead in approaching the Department of Education, so that we're able to find a suitable and better solution towards the issue. The second one, Chair, is in terms of the carbon tax, which I think, Chair, we heard what the National Treasury and SARS is saying. But what the question that I have to National Treasury, Chair, is in terms of the impact that this is going to have in terms of the developmental objectives that government has. I mean, already you look at, for instance, a fuel refinery. what we are doing now might be to exacerbate the import in terms of fuel related products in the country. But secondly, Chair, is in terms of development of such industries in the country. What are we saying? I mean, already now we have seen that a lot of the smelters have closed down, not because of carbon fuel tax, I mean, carbon tax, obviously, but because of a shortage of energy and so on. And in this country as well, we're not in a position to have the inputs that your greener products would actually be produced. And I don't know if we do take that into consideration, whether it's issues of the growth of the economy at that level. I mean, if all those areas are closed down, what does it mean? Now, if you have enough fuel, but it's going to create even more burden to those companies that would want to reopen those smelters and so on. I'm just saying that, is there a balance between the development objectives of the country, that is in terms of growing the economy, but balancing it obviously with environmental factors and so on? I just want to understand that. Thanks, Chair.
Thanks, Honorable Squati. National Treasury, SARS, can you respond to those issues raised by Honorable Squati?
Yeah, thanks, Honorable Chair, Honorable Members. Okay, there are quite a few comments we've noted on the process, which we said we'll work at. On the CIS, there are a lot of comments on collective investment schemes. We are looking at that issue. We're trying to do a response document based on the comment received on the previous discussion document, and we can assess these other issues that were raised today and have been put forward to us. On the schools, yes, so we've had this meeting. The problem is some of these schools have been non-compliant. So they've claimed VAT refunds when they shouldn't have claimed refunds. And now how do we unscramble this egg? So we will try and engage with SARS and them and Department of Health about what we need to do to try and fix this. They've asked for amnesty so that they don't need to pay it back. And we will have to consider, we have given some quite longer timelines in terms of how they can be paid, but we might need to do more. On the carbon tax, we certainly do worry about the developmental objectives and what we need to do and the impact on the economy. The tax has been at a relatively low rate for quite a few years and starting to now go up. There's been a bit of research that's been done on this. We need to do a bit more in terms of the impact on the economy. I mean, I would like honorable members to note that we did put out a discussion paper last year where we had much higher increases in the effective rate. But because of a lot of the comments that we received from industry, in terms of the impact that it would have on them and on jobs, we did pull back quite a bit from those proposals. And in the budget this year, we didn't implement those large increases in the effective tax rate. This was to some of the consternation of other NGOs and other entities which are trying to push for more action to reduce emissions. But at the moment, it looked as if the balance, we had gone a little bit too far. So we did pull back to try and give a little bit of relief while still having a price on carbon so that industry can reduce carbon emissions so that we can meet our nationally determined contributions. But that is an ongoing discussion and we will try and get more research on those. I don't know if there are other comments from my colleagues or from SARS that they want to make.
Yes, if I may.
Yes, go ahead.
Okay, with regard to the low value goods, please accept our apologies for not responding to that at this point. But the response is simply that we are busy liaising with SARS IT team to try to expedite this matter and to try to understand how much longer it needs. We can't obviously, I think Franz can perhaps, if he has anything to add to this, because on our side, difficult right now to give a timeline for it, SARS IT team. Yeah, with the VAT rate issue as well, this is something we've discussed on section 7.4. Because it was not included in this draft that that went out for comments and that was tabled, we are taking this forward to the next legislative cycle to then have more constructive discussions on this with the taxpayers, and I think that will give it a lot more meaning. Thank you.
Thank you, Franz.
Great, thanks. So just to come in on the VAT issue on imported goods, I think what may be lost of in this debate is that there are two classes of imported goods. The first class is the class where there is an import duty because we have a domestic industry which we want to protect. And I think this is where PKF is coming in. And for those goods, we have already imposed the VAT because that is part of our system. There is no difficulty in doing so. So both import duties and VAT are being imposed on those goods. There is, however, the second class of goods, and these are goods where no import duty is imposed. So we haven't previously had to charge VAT on them. And so now what we need to do is create a system that can do something that has not necessarily been done before. And that's why there is something of a delay, but it is a much smaller subset, and it is not in industries where it has been found necessary to protect them through the imposition of import duties. And then just staying on the VAT aspect, I note the comments that have been made about whether or not Section 7.4 is constitutional or not. Those are all arguments that will be presented to the High Court in January next year. And I suspect all those concerned and the broader public will be very interested in the outcome of that particular case. Thanks.
Thank you, Chair. We're done from our side.
Okay, thank you. We are at 7. The book, are there announcements?
Yes, that tomorrow will then be closed deliberations on the bills themselves, the 3 bills, and then adopting the reports.
Okay, it will be at 9.
Yes, it will still be an online meeting, 9 to 12.
Okay. Thanks very much. Let's adjourn the meeting and meet again tomorrow. Thank you.
Thank you.
Thank you, Chair. Thanks, honourable members.
Thank you.
Thank you, honourable members.
Thank you.